Imagine being embedded in a justice system where you can be ordered to surrender your physical liberty without a single criminal conviction.
Right, a system where minor offenses are defined entirely by the subjective discretion of the person prosecuting you.
Exactly. A system where your constitutional right to silence is fiercely protected, right up until the exact moment your military duty requires you to speak. Welcome to the machinery of military discipline. This is the only time you will hear this, called the Blue Suit Files.
We are extracting the operational logic of Chapter 21 of Air Force Handbook 1, Military Justice.
And our focus here is intensely clinical. We are dissecting the structure, the execution, and the brutal consequences of military law. Our objective is to calibrate your understanding to a very specific threshold, the Level B comprehension standard for a technical sergeant.
Well, we need to define that standard first. If you look at the Airman Development and Testing chart, the ADTC Level A is just remembering. It's rote memorization of facts, dates, form numbers.
Which is practically useless in a complex operational environment.
Exactly. Level B is understanding. It requires constructing actual meaning from these written directives. You have to interpret, classify, and explain. You must understand the complex relationships between these written laws and the physical reality of the military environment.
You are essentially required to comprehend how the theoretical framework of military justice translates directly into operational authority and, more importantly, your individual liability.
So we are not analyzing civilian justice today. We are deconstructing a bespoke system designed for a unique global environment.
Let's start with the fundamental premise from Air Force Instruction 1.1. The military environment requires a completely separate system of laws because military discipline directly enhances combat capability.
Right. The primary goal here is not the protection of the individual from the state.
No, it's the exact opposite. The civilian justice system is designed to protect the individual from the overreach of the state. The military justice system is designed to protect the state from the undisciplined individual.
But that creates a severe structural tension.
It does. If the system prioritizes combat lethality above all else, how does it avoid destroying the morale of the very personnel required to execute that lethality?
The balance is maintained strictly through the perception of fairness. A fair and impartial system safeguards the morale of those risking their lives. If the machinery of justice operates arbitrarily, or if the enlisted force perceives it to be corrupt, the internal structure of the fighting force just deteriorates.
It collapses from within.
Exactly. The system has to be brutal in its efficiency, but absolutely flawless in its procedural fairness.
So let's deconstruct the foundation of the system. It doesn't just exist in a vacuum. It is supported by four primary pillars. We have the United States Constitution, the Uniform Code of Military Justice, the Manual for Courts-Martial, and legal precedents.
Starting with the Constitution, that provides the baseline authority. The framers established a strict separation of powers. Article 1 grants Congress the legislative authority to make rules for the military.
Right, the power to declare war, raise and support armies.
Yes, and conversely, Article 2 designates the president as the commander-in-chief. That grants the president the power to issue executive orders governing the military.
But the Constitution is a broad philosophical document. It doesn't tell a commander how to handle a technical sergeant who falls asleep on post or outright refuses a direct order.
Well, that operational gap was bridged by the second pillar, the Uniform Code of Military Justice, or UCMJ.
Which didn't even exist until 1950. So what was the systemic failure prior to that? Why create a uniform code?
It was a direct response to the aftermath of the Second World War. Prior to 1950, the distinct branches of the military operated under completely disparate legal codes. But following the unification of the armed services under the Department of Defense in 1947, Secretary of Defense James V. Forrestal recognized a massive operational vulnerability.
Because you can't manage a joint force global environment when a soldier and an airman have different definitions of criminal conduct.
Exactly. Forrestal required a uniform system of discipline applicable to all services. So Congress enacted the UCMJ.
And the UCMJ is comprehensive. It encompasses your standard criminal acts, murder, arson, larceny. But those aren't its primary focus. It fundamentally regulates crimes that are entirely unique to the military environment.
Right. Military-specific crimes, desertion, absence without leave, disrespect toward superiors.
Failure to obey orders, dereliction of duty, malingering. It also strictly punishes operational failures. Things like misbehavior before the enemy, improper use of a countersign, aiding the enemy.
In the civilian world, those are actions that might get you fired from a corporation. But under the UCMJ, they are federal crimes carrying the potential for severe confinement.
But again, a statute is just a list of crimes. It isn't a procedure. It doesn't give you the exact steps for walking into a courtroom.
And that procedural translation brings us to the third pillar, the Manual for Courts-Martial, or MCM. This is the tactical guidebook utilized by military justice practitioners worldwide.
Issued by the president via executive order under that Article 2 authority.
Yes. It translates the statutory language into actionable procedure. It's divided into 5 distinct parts. Part 1 is the preamble, detailing the sources of authority. Part 2 contains the rules for courts-martial, or RCM.
Let's examine those mechanics. Are the rules for courts-martial alien to the civilian system, or do they mirror it?
They mirror the federal rules of criminal procedure very closely. The military system intentionally adopts the procedural rigor of the federal courts to ensure that perception of fairness we discussed earlier.
What about the rest of the manual?
Well, Part 3 contains the military rules of evidence, the MRE. That dictates exactly what evidence is admissible and what is excluded. Part 4 details the punitive articles.
The granular elements of the charges.
Right. It breaks down exactly what the prosecution must prove for every single offense. And finally, Part V outlines the rules for non-judicial punishment under Article 15.
So we have the Constitution providing the authority, the UCMJ providing the list of crimes, and the MCM providing the procedural rulebook. But a manual cannot anticipate every factual anomaly.
It can't. Gaps inevitably emerge when written regulations collide with human behavior, and that introduces the fourth pillar, legal precedents.
So the prior decisions of appellate courts.
Exactly. When a military judge makes a ruling, and that ruling is appealed, appellate courts, like the Air Force Court of Criminal Appeals, review the decision. Their written decisions establish binding rules for all future courts-martial.
They complete the legal framework right where the statutes end.
Right. If the MCM is silent on a highly specific evidentiary issue, the precedent dictates the operational reality.
Now let's shift to the human element operating this immense machinery. The commander. Their greatest power is discretion.
Discretion is the absolute authority to decide how misconduct is resolved.
They evaluate an offense and choose a path. They can take no action. They can initiate an administrative reprimand. They can offer an Article 15, or they can prefer court-martial charges. They act as the absolute filter for the system.
However, a recent systemic shift has fundamentally altered this framework. Congress recognized a massive liability regarding commander discretion in cases involving highly sensitive crimes.
So they amended the UCMJ and created Article 24A.
Yes. Article 24A establishes a specific category known as covered offenses. These include sexual assault, murder, domestic violence, and child pornography.
And jurisdiction over these specific crimes has been entirely removed from the commander's discretion. Authority over covered offenses now resides exclusively with the Office of Special Trial Counsel, or OSTC.
It's a massive restructuring.
It's basically a corporate restructuring of justice. The military realized unit commanders had a severe conflict of interest. You have a commander charged with maintaining unit cohesion and morale. Asking that same commander to impartially investigate and prosecute a devastating high-profile crime within their own ranks, it creates an impossible structural tension.
So the system removed the middle manager's ability to handle high-liability crimes.
And outsourced that function to an independent specialized auditing firm, the OSTC.
Exactly. The OSTC operates entirely outside the normal chain of command of the accused. They make the binding determination on whether to prosecute a covered offense, isolating the decision from localized unit politics.
But for all non-covered offenses, which is the vast majority of misconduct, the commander retains full authority.
Right. They still prefer charges and forward them to a convening authority.
Let's transition to the burden placed on the individual airman, specifically the technical sergeant at the Level B comprehension threshold. The text mandates that airmen must become involved when breaches of discipline occur.
We have to acknowledge the vagueness there. The text uses the word involved, but it doesn't explicitly define the physical parameters of what that means.
But legally, it implies a duty to act.
Yes. Legally, it implies a mandatory duty to intervene, investigate, or report the incident up the chain of command.
So turning a blind eye isn't just poor leadership.
No, it is a direct violation of systemic regulations. You can be charged with dereliction of duty for failing to become involved. You are structurally required to act as a localized enforcement mechanism.
And this duty to act forces an immediate collision with highly specific administrative traps. Look at Department of the Air Force Policy Directive 3629. It requires all enlisted members to report any civilian criminal conviction to their supervisor within 45 days.
Right. If a junior enlisted member gets a misdemeanor speeding ticket off base, they have 45 days.
But AFI 11 accelerates this timeline significantly for higher ranks. For a technical sergeant E6 and above, you must report any violation of civilian criminal law in writing within 15 days of the date of conviction.
The system simply cannot tolerate a delay in identifying criminal liability at the NCO tier of leadership.
And failing to meet that 15-day deadline is not a paperwork error.
It's an independent, actionable breach of discipline. You can be prosecuted for the civilian offense through concurrent jurisdiction and independently prosecuted for failing to report it.
But wait, this strict requirement for disclosure hits a massive constitutional wall. The Fifth Amendment prohibits compulsory self-incrimination. And in the military, this right is codified and expanded under Article 31 of the UCMJ.
Which strictly prohibits the use of involuntary statements against an accused.
So if the system demands that you report your own civilian conviction in writing within 15 days, how is that not a violation of Article 31?
That is the exact friction point. The requirement to report a conviction is considered an administrative requirement regarding a finalized public record. It is not an interrogation compelling a confession to an ongoing investigation.
Okay, so when do the Article 31 protections actually engage?
The moment a military authority suspects you of an offense and begins questioning you. If a statement is obtained through coercion or unlawful influence, it is classified as involuntary.
So walk us through the procedural safeguards. What must happen before a commander asks a suspect a single question?
Prior to any interrogation, the suspect must be explicitly informed of the nature of the accusation. They must be advised they do not have to make any statement.
The military Miranda warning, essentially.
Exactly. They must be warned that any statement can and will be used as evidence against them in a court-martial, and they are entitled to consult with military defense counsel.
And if they ask for counsel?
All questioning must immediately cease. If those warnings are not administered perfectly, the resulting statement is excluded from evidence no matter how damning it is.
We've established the heavy burden to self-report, the absolute power of the commander, and the rigid protections of Article 31. Let's look at the actual escalation of force. How does a violation of a regulation translate into physical restraint?
Well, the initial mechanism is apprehension. That is the military equivalent of a civilian arrest.
It's the act of taking a person into custody. And military law enforcement officers hold general apprehension authority.
Yes, but apprehension has a strict hierarchy. Any commissioned officer, warrant officer, or non-commissioned officer can apprehend persons subject to the UCMJ. But the apprehension of commissioned officer by an enlisted member is highly restricted.
It's a severe inversion of the normal rank structure. So when is a technical sergeant authorized to physically detain a captain?
Only upon specific, direct orders from another commissioned officer, or under absolute exigent circumstances.
Define exigent circumstances.
Situations where immediate apprehension is necessary to prevent disgrace to the service, to prevent the commission of a serious offense, or to prevent the escape of an officer who has already committed a serious offense.
If an officer is actively assaulting someone or fleeing the base, the enlisted member possesses the authority to execute the apprehension.
Correct.
Following apprehension, the system utilizes a clinical spectrum of pretrial restraint. And it is critical to understand that pretrial restraint is not a punishment.
No, it cannot be used punitively. It is a calculated administrative measure to secure the individual.
And it requires two simultaneous conditions. You need a reasonable belief that an offense triable by court-martial was committed, combined with foresight that the person will flee or engage in serious criminal misconduct while awaiting trial.
If both conditions are not met, the restraint is unlawful.
So contrast the four escalating levels of pretrial restraint.
The first, least restrictive level, is conditions on liberty. These are highly targeted direct orders requiring a person to do or refrain from doing specific acts.
Like an order to stay away from the scene of an alleged offense or no contact order.
Exactly. The second level is restrictions in lieu of arrest. This involves broader geographic limits, like an order restricting an individual to the boundaries of the military installation.
But under the second level, the individual continues to perform their full military duties.
Right. They still go to work. Now, the third level is arrest.
And we need to clarify the military jargon here, because arrest in the military differs entirely from civilian terminology. In the civilian world, arrest means handcuffs.
In the military, arrest is a moral restraint. It directs the person to remain within specified limits, like their barracks room. But there is no physical restraint, no locks, no guards.
It's an honor system backed by the threat of severe federal charges.
Yes, you aren't physically blocked from walking out the door. But if you do, you commit an entirely separate, severe violation of the UCMJ. And unlike the previous level, a person in military arrest is not expected to perform full military duties.
Their status has shifted from a functioning asset to a secured subject, which brings us to the fourth and most severe level, confinement.
Confinement is actual physical restraint. You are placed in a military confinement facility.
Because it's a complete deprivation of physical liberty, it requires probable cause. The authorizing authority must possess a reasonable belief that an offense was committed, that the specific person committed it, and that lesser forms of restraint are simply inadequate.
And the confined individual must be immediately informed of their rights and the procedures for a review by a military magistrate.
The intersection of military readiness and the Fourth Amendment creates a highly regulated environment regarding privacy. In the military, a search requires a search authorization,
Which is the military equivalent of a civilian search warrant. It requires probable cause, a reasonable belief that the specific property or evidence sought is located in the place to be searched.
Furthermore, the commander authorizing the search must be neutral and detached.
Yes, if a commander is actively investigating an airman, they lose their neutrality. They cannot authorize a search against that airman. They have to go to a military judge or a higher commander.
But wait, if a commander needs probable cause and neutrality to search a specific room, how are random vehicle checks the installation gate legal? How are unit-wide urinalysis sweeps legal? Those occur without probable cause and without a specific target.
That is because of a critical systemic distinction defined by the Manual for Courts-Martial. The distinction is between a search and an inspection. An inspection is not a search.
Explain that distinction. What makes an inspection legal without probable cause?
The primary purpose. The primary purpose of an inspection is to ensure the security, military fitness, or good order and discipline of a unit. It is an administrative mechanism to ensure readiness.
It doesn't target particular suspect.
Right. A commander can order a 100% inspection of the barracks to ensure compliance with safety standards. No probable cause is required.
But here's the loophole. If they're inspecting for safety and they happen to find illegal drugs in a locker, what happens?
The drugs are entirely admissible in court. The inspection mechanism circumvents the need for probable cause because its primary purpose is readiness, but it simultaneously allows for the prosecution of offenses discovered during the process.
Unless defense counsel can prove the inspection was a pretext.
Exactly. If the commander actually suspected a specific airman and ordered a whole unit inspection just to get into that airman's locker, the military judge will rule it an unlawful search, and the evidence is suppressed.
Let's discuss what happens when a commander determines misconduct occurred, but doesn't believe it warrants a federal court-martial conviction. They utilize the middle ground. Article 15, non-judicial punishment, or NJP.
NJP corrects behavior without the permanent stigma of a federal conviction, and the regulation explicitly states it is intended for minor offenses.
Again, we have to acknowledge the vagueness of the text. What is a minor offense?
It is left entirely to the imposing commander's discretion. The guidelines suggest a minor offense is one that would not warrant a dishonorable discharge or more than a year of confinement if tried by a general court-martial.
But that's just a guideline.
Yes. An offense that one commander considers minor might be referred to a court-martial by a different commander.
And the standard of proof under Article 15 diverges sharply from civilian criminal courts. Civilian courts require proof beyond a reasonable doubt. NJP uses the standard of preponderance of the evidence.
Meaning the commander must only determine that it is more likely than not that the member committed the offense. If they are 51% convinced, they can impose punishment.
Because of that lower standard, the clinical process is heavily documented, and the forms are separated by rank. AF Form 3070A is for Airman Basic, through Staff Sergeant. Form 3070B is for Technical Sergeant, through Chief Master Sergeant.
The systemic logic there relates directly to career trajectory and the severity of collateral consequences. A potential rank reduction for a technical sergeant is structurally more complex than for an airman basic.
The member is granted 72 hours to evaluate their options and either accept or demand a court-martial. And we need to clarify a crucial point here. Accepting an Article 15 is a choice of forum. It is not an admission of guilt.
Absolutely not. By accepting it, the member simply agrees to let the commander decide the case using the preponderance of the evidence standard. They retain the absolute right to present matters in defense, bring witnesses, and argue their innocence.
If the member demands a court-martial, the Article 15 process immediately terminates. But if they accept it and the commander finds them guilty, punishment is imposed. However, that punishment is constrained by Table 21.1 of the handbook.
The permissible severity scales precisely with the rank of the commander and the rank of the offender.
Right. A captain cannot impose NJP on a chief master sergeant. Their rank does not carry the necessary authority to adjudicate misconduct at that tier.
And following the punishment, the commander holds 4 specific post-punishment administrative levers: suspension, remission, mitigation, and set-aside.
Let's define those quickly. Suspension postpones the application of the punishment for a probationary period.
Remission cancels any unexecuted portion of the punishment as a reward for immediate rehabilitation.
Mitigation reduces the severity, like changing a rank reduction to a pay forfeiture.
And set aside is the absolute erasure of the punishment due to a clear injustice. It restores all property and privileges.
Now, when an offense exceeds the parameters of NJP, the system escalates to the ultimate sanction, courts-martial. First, you must establish jurisdiction.
Personal jurisdiction verifies the legal status of the accused. They must be subject to the UCMJ. Subject matter jurisdiction verifies that the conduct itself is prohibited by the UCMJ.
But the reality often involves concurrent jurisdiction. If an active duty member shoplifts off base, they violate state law and Article 121 of the UCMJ for larceny.
Meaning they can theoretically be prosecuted by both the state and the military. Double jeopardy does not apply between separate sovereigns.
The Department of the Air Force policy dictates the Secretary of the Air Force must explicitly approve dual prosecutions.
Right. Usually the military and civilian prosecutors just negotiate who takes the lead.
Once jurisdiction is established, we look at the 3 tiers of courts-martial. The lowest tier is the summary court-martial.
It consists of a single commissioned officer. It is a non-criminal forum. It cannot try officers. And an enlisted member possesses the absolute right to object to it.
The second tier is the special court-martial, consisting of a military judge and a 4-member panel. It caps confinement at 1 year.
But there's a specialized subset here, the judge-alone special court-martial.
Wait, if the command uses the judge-alone subset, confinement is capped at 6 months and punitive discharges are removed. Why would a command intentionally choose a forum that limits their own punishment power?
Efficiency. A standard panel trial is logistically heavy. If the command believes 6 months is adequate punishment, they use the judge-alone forum to streamline the process, save resources, and efficiently secure a federal conviction.
The highest tier is the general court-martial, a judge and 8 members, or 12 for capital cases. Maximum punishments, including death.
And let's analyze the players in the room. You have the trial counsel, who are prosecutors, but their ethical obligation is to seek justice, not just secure convictions. They have to disclose exculpatory evidence.
You have the defense counsel, ethically bound to zealous advocacy, the military judge who acts as the impartial referee of the law, and then you have the victim's counsel, or VC.
The VC provides independent legal representation directly to the victim,
which injects a deliberate friction into the courtroom. The VC is allowed to oppose the United States government to protect their client. If the trial counsel tries to subpoena the victim's private medical records, the VC will fight the prosecutor to quash it.
Exactly. They protect the individual interests of the victim, regardless of how it impacts the Air Force's ability to secure a conviction.
Let's talk about the verdict, the findings. In civilian trial, a guilty verdict requires a unanimous jury vote. In a military court-martial, it requires a concurrence of at least 3/4 of the members.
So if a panel has 8 members, 6 must vote guilty to secure a conviction.
The only exception is a capital case involving the death penalty, which requires a unanimous vote.
Now, once judgment is entered, the system's fail-safes activate. Appellate review.
Trace that path for us.
Initial review is conducted by the Judge Advocate General. But for severe sentences, review is automatic by the Air Force Court of Criminal Appeals, or AFCCA.
Which is composed of at least 3 military appellate judges. If they uphold the conviction, it escalates to the United States Court of Appeals for the Armed Forces, or USCAF.
And that court is entirely civilian. 5 judges appointed by the president. And finally, the absolute final mechanism of appeal is the United States Supreme Court.
Let's synthesize this level B understanding. The military justice system is not a rigid list of rules. It is a highly fluid ecosystem. It balances the overwhelming power of the unit commander against the independent oversight of the OSTC and the appellate courts.
It demands aggressive individual accountability, using mechanisms like the 15-day reporting rule while simultaneously protecting against self-incrimination.
And comprehension of this system requires an absolute understanding of precision. The difference between an arrest and confinement or a search and an inspection is not semantics.
No, it is the exact boundary line between a lawful military order and a severe violation of constitutional rights. The system relies on absolute precision to preserve its legitimacy.
You are embedded in a justice system where you can be ordered to surrender your physical liberty without a single criminal conviction, where minor offenses are defined by the person prosecuting you, and where your silence is protected right up until the exact moment your military duty requires you to speak. The system is designed to be flawless in its execution of lethality. The question you must answer is this: when the machinery of military justice turns its focus onto your unit, are you the operator at the controls, or are you just a cog caught in the gears?